what would it be like if I could reach the person that's sitting in front of me 5 years ago and give them 5 tips of how to avoid ever having to sit in my office and with the prospect of filing a lawsuit against their partner or partners. Hi, I'm attorney Jay Farrow, and I'm a commercial litigation attorney. Most of my practice involves partnership disputes. That means by the time that you're sitting in my office, you're telling me about a complaint you have about your partner or your partners. And I thought to myself, after practicing in this area for as long as I have, if I could have just reached this person 3 years ago or 5 years ago, all of this could have been avoided. So I want to make an informational video about what I have seen to be the few things that you could do to avoid ever having to sit in my office and talk about the prospect of years of litigation in suing one of your partners. The first thing is clarity between you and your partner or partners. Do you have the same goals? Do you have the same visions? A lot of times in partnerships, you have one person who's the investor and then one person who knows the industry. I call them the partner A and partner B. And over time, what ends up developing is that the finance person doesn't understand what the industry person knows and what they're doing on a day-to-day basis. And because it takes a long time for a business to start making profits, they get antsy about how is it that this company isn't making money. I thought this would be what it's called plug and play. The upfront discussion that you're going to have with your potential partner is critical to identifying what do you know and what do you expect out of the relationship. If in fact someone's going to be giving money and someone has the experience in a particular industry or has the connections in a particular industry, lay it out on the table. What is the plan that you can align on? What are the expectations of each partner? Because sometimes the person that has the industry knowledge wants the person that does the investing to do more. And that creates angst and resentments and leads to potential litigation. All right, the second thing that I would advise, which is even more important than aligning on a strategy and the goals for the partnership, is what I like to call the worst case scenario or having an exit plan. If things don't go as planned, how do you dissolve the partnership? Sometimes the business has equipment, sometimes it has other types of assets, and it's important to be clear up front that if one partner gets sick, doesn't perform, or God forbid passes away, what are the mechanisms under those circumstances that could be followed such that you can easily exit out of the partnership with less consequences financially for both parties and less chances that you'll end up litigating the case against your partner, especially when things don't go as planned. Because believe me, if there's one thing that this business has taught me about partnerships is that nothing ever goes as planned. The third thing that I would tell somebody some years before they sit in my office is do as much due diligence on the human being that you're about to get into a partnership with. Nowadays, there's so much that can be found on the internet about people, businesses that they've owned, litigation that they've been involved with, charities that they may be involved with. There are so many things that people put out on social media that tell the world about who they are. Because if someone is telling you who they are, believe them. And sometimes that's not always directed towards you in your initial conversations. In other words, do your homework. You're about to get into a marriage because that's exactly what a partnership is. And under the law, once you have a partnership agreement, it's almost the same if you have to dissolve the partnership as you're dissolving a marriage. So don't forget that while in theory, the pieces might seem to fit. Somebody might have the money, somebody might have the know-how, somebody might have the connections. If you know that you couldn't get along with this person or find a way to coexist with that human being or have issues with some of the things that they have done in their life, it's probably a good idea to end that conversation regarding entering a partnership with that person right away, sooner rather than later. Because in most of my cases, one of the partners has committed fraud, a breach of the agreement, or some other serious things such as taking money out of the corporate bank accounts, spending money on corporate credit cards. And all of this could be avoided if you do your homework, really get to know the person or persons that you're going to enter the partnership agreement in. So I'm going to condense the fourth and fifth steps here. And I would say, number one is that once you've sketched out your goals and your strategy, your exit plan, find yourself a lawyer that knows how to build corporate architecture, like an LLC operating agreement, corporate bylaws, or a partnership agreement. Because there are, in the case of limited liability companies, statutes that provide for what's in and what's out of those type of agreements. And you really want to know the ins and outs. And it's worth spending the money up front. And it can cost what it costs for drafting these agreements because they are unique to your partnership. And once you have it down in writing, don't ever forget that both of you have the right to go seek independent counsel other than that lawyer to review and negotiate the terms that you want. While you can use the same lawyer, if you have issues with the drafting, or if it's the finance person that's paying for the lawyer, you might want to think about having another lawyer check out the work and point out some things that you might have missed before you sign that agreement. Because once the agreement's signed and you're off and running, it's very, very challenging, short of litigation or a lot of other headaches, to switch that agreement or modify it.